Good evening from the Bay Area. My name is Jason Putnam Gordon, and you are here at Idea to IPO for how to do a venture capital financing. We've got a great conversation, great topic today. We're going to move through it. Before we do, I want to provide you with a little bit of background of how today's event's going to go. So I'm going to speak for about an hour. Throughout today's conversation, I'm going to pause every slide or a few slides and see if we can take some topical questions. If you've got a question, terrific. Ask it using the Q&A function. It's easier for me to track. Not only am I presenting today, but I'm also running all the tech in the background. And so with that in mind, I don't want you to, I don't want to miss one of your questions. Probably a good one. Now, a couple of other comments. Today's conversation is going to be, and presentation is going to be recorded. So the good news is if you miss some or all of it, as long as you've registered, we'll send it to you about a week or so afterwards. If you ask a question, then just also know that the answer may be, will be recorded, and anything you say may be, memorialized for posterity. And so please don't share any confidential information. And we'll go into a little bit more about that in a moment. But with that in mind, without any further ado, I think we should begin. So again, today's topic, how to do a venture capital financing. I'm Jason Putnam Gordon. You're at Idea to IPO. Glad you could join us either in real time or as recorded. So a couple of important caveats. Today's discussion is general information. It is not legal advice. We will be talking about rules and exceptions to rules. We'll be talking about some of my experience and observations. We may talk about some of your experience and observations. But please understand that, if you're going to be doing a venture capital financing, that's great. Make sure that you retain a competent counsel, legal counsel, who specializes and focuses in this area to guide you through that process and to make sure that you're getting advice tailored to your specific situation. With that in mind, the corollary is my off-the-cuff answers to your questions, whether today or whether or not we connect, in office hours. I keep office hours. You can connect with me on LinkedIn. My email is jgordon@polsonelli.com. If I answer these questions sort of off the cuff, they're to give you general information as to what I've seen and observed in the market. It's not to be tailored to your specific situation. So, overview of how today's conversation is going to proceed. I'm going to talk a little bit about my background. We're going to start at a high level. We're going to start out talking about what the venture model is. I'm going to do a survey. We've got a lot of first-time entrepreneurs in here, a lot of folks at early stage companies. I think it's always very helpful to understand what the venture capital model is. We'll kind of talk about what the ideal VCs are from a company's perspective, some of the things that you should be keeping an eye out for. Then we'll talk about preliminary considerations, things you should be thinking about before you start your fundraising process. We'll talk about term sheet negotiation. We'll talk about deal documentation. We'll move on to diligence, which is something that's very fun and interesting and quite an exercise if you've not done it before. We'll talk about side letters, and then we'll move on to posing post-closing issues, and then we'll wrap up, if we've got time, with sort of war stories, pitfalls, and finally, of course, the last half hour of our time together will be just purely Q&A. And in that period of time, I'm going to be focused on questions or trying to answer questions of broad applicability. So glad you could join me. Now, let's talk just briefly before we move on about who's going to get some value out of today's conversation. So if you are about to raise venture capital financing, you're in a sweet spot, good place to be. If you are in the process of raising seed financing, and we'll talk about kind of the difference between seed financing and venture financing in today's conversation, but also a great spot. If you are interested in forming a company that's going to be venture-backed, you're in a great spot to be. You're going to learn a lot. This is going to be very helpful for you. If you just want to understand the ecosystem a little bit better, the venture ecosystem, also a good spot. And if you're just striving to learn more knowledge about venture, this is also a great spot to be in. That's who's going to get the most value out of today's conversation. So my background, I'm a venture capital and emerging growth company attorney. I've been practicing law since 2005. So what does a VC EGC attorney do? Well, I work with venture-backed companies from when they form, through their financings, through their exits. I generally serve as outside general counsel as well, helping play air traffic controller for all their disparate legal needs. And on the investor side, I work with venture capital funds and angels as they deploy capital. And I'm at Pulcinelli, which is an AmLaw 100 firm with over 20 offices in the US and I think over 900 attorneys at this point. I am based in San Francisco, but I work with companies all throughout the, obviously in the Bay Area, all throughout the US and also over the world. One of the wonderful things about being in the Bay Area, it's just part of Silicon Valley, is that there are a lot of inbound international companies. So I'm sure we have a lot of folks from outside the US. Perhaps they want to come to the US, maybe the Bay Area in particular. And I work with those types of companies. And I love working with entrepreneurs on financings and also as serving as outside general counsel. Before I worked at Pulcinelli, I was at a large shop. I then opened my own shop for a while and ran a boutique focused in this area and space. I loved it, but I needed to get back to a big shop because growing client needs and, just all kinds of different things, all kinds of different legal specialists are necessary to help venture capital companies grow. So that's why I'm back in a big shop and I love it too. Let's before we kind of move on to the model, let's just see who's in the room. So I'm going to end polling. I'm going to share the results. We've got, no surprise, maybe about a third of the people from the Bay Area or California. We've got another third elsewhere in the US. We've got some folks in Asia, some folks in Australia, and some folks from other places, maybe the Middle East. Now, one thing which is great about this event and these types of events is, again, they're recorded. So I'm going to send that to you afterwards. And we frequently find that these, the folks who may be watching this may be 2 o'clock in the morning at their time right now, so they can't make it. In terms of who else is in the room, kind of by category, a lot of first-time entrepreneurs. Typical to see 40, 50, 60% in these types of events. We're definitely within the sort of center of the bell curve here on that. We've got a few serial entrepreneurs. We've got folks who are at early stage companies, growth stage companies, large corporates, got some angel investors, some folks from the government, and also academia. Wonderful. Let's talk a little bit about the venture model and understand not everything is going to definitely fit strictly within this model, but here's a framework of how to sort of think about things. So if you're thinking about a traditional venture capital fund, what happens there is that you've got a fund which has investors, right? They've got their own investors. Those folks are limited partners in the fund, sometimes called LPs. They put money into the fund, and there is a manager who picks the companies to deploy that capital and invest in. And the goal of management there, those partners, is to build a portfolio where there will be a few companies that are huge home runs. That's the bulk of where the VCs are planning on making their money in a traditional fund. Now, they understand that there are going to be a lot of companies that are not home runs, right? There'll be a lot of companies that don't make it. There'll be a lot of companies that are singles, but it's those home runs that they're looking to build to get the return they need to meet their investors, the LPs, in expectations. Now, another thing to keep in mind is that a fund is usually structured, and it kind of depends on the space, but roughly around 10 years. So that means they need to, basically raise the fund, deploy the capital, and return the capital in 10 years. So the investment horizons typically, we say, sort of around 7 years or so. That's what motivates them. Now, in order to sort of get those home runs, they're looking for a particular kind of company. They're looking for a company that requires a lot of capital to grow and scale, so that business is then going to be in the hundreds of millions of dollars, going to be worth in the hundreds of millions, or more likely even in the billions. And there's going to be an exit, okay? So a liquidity event. So there's going to be a way to get their capital back out That's typically either a merger and acquisition, most common, an IPO, which is sort of the most talked about, maybe a SPAC, and that's a topic for a different conversation, or even a direct listing. That's become popular in the last sort of 5 years or so. And that's what they're looking for. That's the primary motivation. Now, you can have either generalists who will invest in companies across different verticals, or specialists who will invest companies within specific verticals. And there are pluses and minuses with each of them, and we might have a chance to sort of flesh out a little bit more. Now, angel investors have different considerations. Now, what motivates an angel depends on the angel, right? Some of them are just interested in the technology. Some of them want to maybe support the founders, right? Friends and family might fit into that bucket. Some angels may want to just support innovation in a particular area. Do a good amount of work with climate tech and climate-related companies. So a lot of support in there. Some angel investors were entrepreneurs themselves, or were maybe early employees at successful startups. They've seen their company grow, scale, exit. They've got a lot of capital and they want to nurture the ecosystem. So we see a lot of that redeployment. So those are some of the things that motivate angels. Strategic investors bring a different perspective to the table. They might be a company that is focused on innovation, but concerned that their own internal innovation pipeline is not sufficient. So what does that mean? Well, I've sort of heard it said before that, the skills that it takes to start a company from scratch, build and grow and scale it, are different than those of running a large company. And so if you've got a large company that's up and running, it may not be able to innovate as well, right? And so that would be the corp dev pipeline, right? Thinking about the next innovation so that they can buy it rather than build it. Other strategic investors sometimes want to do things like keep competition, keep tabs on and or kind of limit or even stifle kind of competition in their area. So that's one thing to be mindful of. Others kind of go a different way, right? So maybe they want to support development of companies that are going to drive sale of their product or service, right? So, primary example would be like Intel wanting to sell more microchips, right? So they'd invest in companies that are going to, their products and services are going to require microchips, things like that. Now, I share this with you because I think that it really does frame the lens that you need to have as you're, considering raising venture capital. You got to know who's sitting on the other side of the table is another way to put it. And the way I see it, and we'll move through this slide quickly. From a legal perspective, we're kind of all about tying relationships into the company. So that's the capital from investors. Those are the intangible ideas from founders and other folks. And then the services that get rendered by technicians, sales folks, and other people like that into the company. And, do that, give it some time, and hopefully the company is going to grow and increase in value. And, there's a model, there's a pattern here. And before we move on to that pattern, I'm going to just pause and see if we've got any questions today. Please use the Q&A function. I'm going to take a quick drink of water as well. Okay. Again, if you've got questions, please use the Q&A function. It's easier for me to track as opposed to the chat. If you want to communicate with other folks in the chat or in the room, feel free to use the chat. Now, venture capital model continued. So when we see this, we can typically break it up into stages. So the early stage company is about putting together its initial team, getting together its initial product, and maybe initially going out and doing some sales to some customers, get those initial customers. And that's kind of in the seed stage where we see investment from angels. And when we do that, we typically see that, the form of the investment comes in either a convertible note or a simple agreement for future equity, that's a different presentation. We're not going to talk about it today, other than to just mention that it's out there. After a company, and it sort of, again, depends on the vertical. If you've got a drug development company, it's a different situation, but sort of typical SaaS or consumer product or, other company, the venture capitalists typically come in after the initial team's together, the initial product or service is out there, and they're starting to get market traction. And what they're looking for is, all right, these folks have already figured out what's going to sell. What's holding them back is not product market fit. It's capital to be able to sell more product to generate that revenue. And when they do that, that's when we start talking about a price round and a venture capital financing. And we're going to talk about what are the attributes of that. All right, so from a company's perspective, before we do that, let's kind of talk a little bit about who to think about being a good investor. Some people say money is fungible. A dollar in one bank account is the same as a dollar in another bank account. And that's true when we're talking about money. But what you have to understand, going back to what we mentioned earlier in this conversation, is that these investors, especially early stage investors, are going to be on your cap table for 7 years, plus or minus a couple. So they're long-term partners of sorts, and you want to make sure that you've got the right relationship in place. So from a company's perspective, that's typically looking for investors who can add value beyond just the dollars in. Those are VCs, or maybe when appropriate, and maybe we'll get to talk a little bit more about strategics in a little bit, but maybe it's the strategics, but they can unlock talent because of access to a talent pool that they keep. They could unlock, and they don't have to have all these things, but these are the types of things that you'd be looking out for. Unlock talent, unlock customers, unlock suppliers, bring cachet, so it's easier to raise funds from other folks. All kinds of attributes like that. You also generally, if you're the company, want investors that understand your space and can be supportive of the company for that horizon. If it's an investor who's focused on a quick return, and it's an early stage financing, that doesn't really jive with the model, which we just sort of talked about. And so one of the concerns will be that you'll get kind of crossways towards each other pretty quickly. And as you'll see, investors do take on some, venture investors do take on some control rights. And that's a way for them to mitigate risk, right? That's a way for them to mitigate risk of loss of their funds. Great, just got some good feedback. We'll keep chugging on. Now, let's just talk a little bit of definitions here. We're not going to go heavy into running pro forma cap tables today. That's also a different conversation, great conversation, but we're not doing that today. But I do think it's helpful. So, one of the things about being in the space as long as I have and studying it and working it and living it and breathing it is, you kind of know these definitions are not hard and fast. You got to always look at the fine print. With that in mind, by and large, if you're raising money from a VC or a strategic and you get a term sheet, there's going to be term pre-money valuation, term post-money valuation on there. And in that context, and I say in that context because it can differ by SAFE and it can differ by convertible note and it can differ in a couple of other situations. But in the context of getting a term sheet from a VC, the sort of typical framework to think about a pre-money valuation is the value of the company immediately before the investment comes in. So if you've got a company that has got a $40 million pre-money valuation and there's going to be $10 million of investment and the pre-money is 40. Once that money comes in, you just add those two things together. That's how you get the 50. Again, you got to read the fine print on all of these things. Some of this stuff is negotiable, and it can vary if you're looking at safes and convertible notes, but let's not get ourselves too tied up in knots over that right now. Now, the other sort of term that you see gets bandied about a lot, and the sort of general definition for that, again, is think about all common stock that's outstanding and anything that can be converted or may otherwise become common stock. That's what we're talking about when we're talking about fully diluted basis. Now, I say can become, so that would be like if you've promised employees issuances of stock or something along those lines, right? It's not, verbally promise them like a napkin promise or something along those lines, right? Which you shouldn't do, but if you do, it would get counted on there and you'd have to fix it or clean it up in conjunction with the financing. The point here is kind of at the end of the day, the investors want to know what percentage of the company they're getting. And we're going to take a real quick look at that in a second. Now, the other sort of strange thing that gets bandied about are the names for different price rounds. So I'm probably going to end up calling these things just price rounds today, but understand I'm talking about, your first price round of venture capital financing, whether that is a Series C, it's called Series Seed, or whether you just go straight to Series A, or whether it's called Series AA, talking about your first price round. Now, what's the difference between Series Seed and Series AA? We'll talk about that a little bit, Series Seed and Series A. We'll talk about that a little bit, but just understand the definitions are a little fuzzy here, and you got to read the fine print. Now, just to give you a sense of what is super important that we're about to talk about is in this preliminary considerations bucket. At the end of the day, if we're talking about a price round, a venture capital financing, we're talking about selling a piece of the company. Now, in order to know how much, what size that piece is, you got to know what's the size of the company, that's the pre-money valuation, and how much of the company, and how much money is being put into the company and what the company is worth afterwards. So that gives you the percentage of what the company is being sold. And that's why the fully diluted basis is so important, especially important to VCs and whether they're funds or strategics, they want to know how much of the company they're buying on a percentage basis. So you can see here, this is just sort of an example of the different categories, and this would actually be more like a Series B financing, if you will, because this on here shows that the safes have converted and some convertible notes have converted. But you have to understand at the end of the day, when you're running these pro forma cap tables, it's not just going to be the common that's going to be listed there. The common's going to be there, the preferred's going to be there, your option plan's going to be there. If you got safes or notes converting, they'll be there. If there's going to be an increase in the option pool because you need to have more, you need to be able to do some hires and you need to be able to grant more options, that's going to be on there. And that's what the VCs are going to be focused on, all with the driving goal of them understanding how much of the company they're buying. Let's keep chugging along here. So I will take questions that are sort of topically on point with the slides. And if you've got other questions, we'll either take them at the end if they're sort of of general applicability. I encourage you to ask questions using the Q&A function throughout this whole thing. So continuing on with the preliminary considerations, before you start talking to VCs, you hopefully have gotten connected to competent counsel. Probably also hopefully got connected to somebody on the sort of finance side, like an outside CFO or something along those lines. You have structured the company correctly. Now that is almost always, although not always, a Delaware C Corp. Reasons for that are usually driven by the investors. So as we mentioned before, these funds are, pass-through entities. So they've got LPs, limited partners, and they require investing in C Corps. Delaware is very common and popular because it has sophisticated corporate law. It's generally thought to have better protections for directors and officers, and the VCs are going to ask to put, almost always going to ask to put somebody on the board. So they'll want the liability protection. There's the Delaware Chancery. There are a few other reasons. We're not focused. Today's conversation is really more about how to do the venture capital financing than this. So we'll just keep kind of chugging through. Other buckets, and we can come back to it later if you've got questions. Other buckets of important things under correct structure is making sure all the IP is assigned in the company, making sure that there's the right kind of vesting schedules and other things in place with the founders and other employees. We'll talk more about that more. Now, modeling the rounds, we just sort of previewed a little bit what that's like. That's sitting down with your finance person and probably also having your lawyer look at stuff, look at it at the end and just making sure that you've run that pro forma cap table, right? It'll look a little bit different than this, but this is a good example, at least for discussion and educational purposes. And then you got to kind of get a sense for the style of deal you're doing. So in the last I would say probably in the last 6 or 7 years, the National Venture Capital Association's model documents have become more and more relied upon in the industry. Now, that's great. So you can go check them out online yourself. I'm not hiding them from you. Nobody's hiding them from you. They're robust. We'll talk about them in a minute. Their term sheet's 10 pages. Then you got a set of 5, and we'll talk about these 2 docs that are another 20 to 35 pages each. You'd like to think, oh, you just pull one off the shelf. No, I mean, there's going to be a lot of customization, but at least it's a common starting point. That's one style of deal, probably the most common style of deal if you're really talking about a price round. Price rounds, especially in the Bay Area, usually probably at least 3 million to maybe raising more like 5 to 10 and up. 5 to 7 to 10 and up. That's kind of rough rules of thumb that I kind of put on in terms of where you'd be seeing price rounds as opposed to a convertible note or safe. Another thing that's sort of evolved in the last couple of years is like an NVCA light. So it's sort of based on the NVCA documents, but kind of slimmed down. That's nice. It's usually thought to be a little bit less expensive to negotiate. And what was very popular 2013, 14, 15, and still gets done, but is less common, is Series Seed docs on seriesseed.com. We can talk about why that is later. And then historically, kind of each law firm had its own set of preferred financing documents, but those are becoming less and less common these days. So those are some of the preliminary considerations you have with your lawyer. You do the modeling, sort of figure out how much of the company you're targeting to sell. It's probably typically 15 to 30%, with most common around kind of 20 to 25% on a fully diluted basis. But, you can look at your vertical, you can look to see comparables, right? What else is getting done in that space, what the valuations are. You sort of sketch some of that out. And you also have a conversation with your lawyer about what you'd want to see in the term sheet, right? So first and foremost, pre-money, post-money, definition of fully diluted, that's what sets how much of the company is being sold. Okay, and that's the big one. Other terms in the term sheet, and you can pull these off the NVCA website, which I just gave a moment ago, include dividends, which there's kind of a normal range, liquidation preferences. So liquidation preference is basically who gets paid first. And, the way it goes, it's creditors, secured creditors, right? Like if somebody lends you money, well, the secured creditor that most people are familiar with is the bank who's got your mortgage, or a car lender who's got your car note. You're getting your car note from them. The same kind of thing can happen for companies in terms of securing different assets in connection with lines of credit. Unsecured creditors, and then equity gets paid last. But within equity, Preferred gets paid, usually negotiates to get paid first. And then within there can be different seniority, different preferences within there. So negotiating the liquidation preference, who gets paid first and how much, is it their money back? Is it they get paid the greater of their money back or what the common would receive? Or did they get their money back plus what the common would receive? Or they get 2x their money back? Negotiating the liquidation preference. Voting rights as to whether they vote alongside the common and whether or not they get a board seat. Board seats are negotiable. So, if your first price round is maybe not a huge round. Let's say you're doing 3, 5, maybe even 10, and you're an experienced entrepreneur, you're in a really hot space, or you've got a lot of customer attraction, you may not need to give an actual board seat up. You may want to, but you may not need to. And we'll talk about observer seats. That's sometimes an alternative. We'll talk about that in a moment. Protective provisions. These are provisions within the charter, and that's the certificate, the amended and restated certificate of incorporation, which give basically the preferred negative control rights. So before the company can do something, it needs to get the preferred's approval. These are highly negotiated. They contain things, or they govern things like charter amendment, or bylaw amendment, whether you can issue new series of preferred that are senior to what's being issued now. Senior is referring to that sort of liquidation preference and a number of other rights that we just talked about. Control over liquidation events. Okay, why would the investors care about when you sell the company? Well, if they think a certain amount of time and a certain amount of traction needs to get done before they can sell, and they can realize the return they need, they want to have some say in that. So that's where that fits in there. Converting the preferred over to common, not necessarily super highly negotiated. Whether or not a legal opinion is going to need to be given is also on the table, although, again, sort of early stage, not large rounds, it's not as common. Right of first refusal and co-sale, that's the ROFR and co-sale. So right of first refusal, make sure that certain key holders, like the founders and maybe certain employees, if they're going to sell their stock, the company has the first right to buy that stock back. Or a secondary right goes to certain investors, maybe the major investors. Again, to control who's on the cap table, you wouldn't necessarily, and your investors don't necessarily want to have a competitor come in. And a co-sale is a right for the preferred to sell along with that key holder if the key holder doesn't sell all their, if a ROFR doesn't get used on their stock. A way for the preferred to basically get some liquidity if a founder is going to get liquidity. Drag along is that's put together in the voting agreement, drag along agreement, usually setting who's on the board, and then the drag deals with when the company is going to get sold. It's a contractual mechanism to compel people to agree to the sale if some things happen. Usually, majority of the board approves it, majority of the common approve it, or some subcategory of the common approve it, and a majority of the preferred. And the reason for that is not to necessarily force founders to sell. The reason for it is really actually to limit appraisal rights, or to have a mechanism to curtail appraisal rights, which is a separate court action, which allows a disgruntled stockholder to go into court and petition the court to get a different price for the stock in connection with the sale of the company. You might say, well, why is that so terrible? Well, it's very expensive. Buyers who are buying the company, it lends to uncertainty as to the deal. And, you never know necessarily what situation you're going to have in the future, right? So if you've got 3 or 4 founders, it's quite possible that one of them or more of them will exit before that sale of the company. And so you don't want them to have outside leverage, or, You don't want to have too much leverage at the time of the sale to negotiate or to even kill the sale. Registration rights deal with being able to require the company to go public under certain situations. Anti-dilution provisions are a mechanism by which the company, if you have a down round, basically the investors will get kind of topped up, basically. So that's what the anti-dilution mechanism. Vesting for founders, we mentioned this before, right? It's kind of part of the setup. What's pretty standard usually is 4 years of vesting, 1 year cliff. So a founder basically gets their, I'm just going to pause there and I'm going to tell you about vesting. So vesting, most people think about shares of stock be given to the founders, over a period of time. The way it actually works, I think a better way to look at it is vesting founders or other early employees or whoever's subjected to it. It's a little bit different for options, but talking about stock, get all their shares up front, and those shares of stock have strings attached to them. And then as time goes by, strings get cut. And if that founder were to leave, they get to walk away with the shares of stock that the strings have been cut on. Anyway, it's important because the investors are keyed into the fact that many times a founder or someone else will leave, and you don't want them to walk away with a huge chunk of the company if they're not doing any work. It's to require that they have skin in the game, if you will. There are also provisions around documentation. We'll talk about that. Attorney's fees, because of the way, especially for venture capital funds, the way that they're structured, some of their attorney's fees need to be covered coming out of the investment. And then we'll just skip down. No shop provisions, basically not allowing you to shop the deal to other VCs or other folks. We'll talk a little bit more about board seats and observer rights. We already sort of talked about that. And the pro rata rights are the ability for investors to buy in at the next, certain investors to buy in the next round and maintain their relative position in the company or close to the relative position in the company. And that is important because let me give you a piece of context here. When VCs deploy capital, there are a few ways that they kind of help mitigate their risk. Some of the provisions we're talking about now are one mechanism to do that. But another sort of structural way that they do that is they will frequently, make investments alongside other VCs and other strategics. And so, rather than making one big investment, they can make sort of a smaller investment with the goal being, if it turns out, yes, that entrepreneur or entrepreneurs are terrific and are executing, we'll put in more money at the next round. And so that's what pro rata rights are securing. And we'll talk a little bit more about those during our side letter discussion. So I'm going to just see. Somebody's asking whether or not I've advanced the slide from preliminary considerations. We're on the typical term sheet slide right now. What's the typical conversion of preferred stock to equity stock, same wise on converted debt note to equity? That is a different presentation, but again, connect with me on LinkedIn or send me an email. We do that presentation kind of all the time, and I'll help you out there and see what we can do to be helpful. How do VCs validate and ensure the quality of our product? Do they pull in experts or advisors? The answer is yes. So, they're looking at, and this is a non-exhaustive list, but they're looking at a number of risk factors, right? Is the technology doable and workable? And the VCs will pull in experts to advise on that. Are the entrepreneurs the kind of people that we should bet our money on? So they will do background checks and they will look at people's pedigrees and what they've done in the past. And, by and large, is what the entrepreneur is putting together. Can they sell it and can they scale it? And so that's why they're looking to see, some traction in the marketplace. How do they check the statements from pitches communicated by a founder in order to not be deceived? We'll talk about that in diligence. Can you briefly identify the differences between a pre-seed and seed round? That's just marketing nomenclature. I think, probably a rule of thumb is a few $100K is probably pre-seed, and then seed is probably a bit above that. But, there are really no set definitions for these things, and one person's pre-seed is another person's seed, and vice versa. Again, it's kind of branding, whether it's pre-seed, seed, series seed, or series A, it's kind of also about like positioning yourself for the next raise, right? So sometimes people like to kind of do a pre-seed so that they kind of get the pipeline rolling, and it doesn't look like they've just had a small seed raise. But again, it's sort of a branding thing. All right. There's some more questions. We'll get to them in a little bit. Main financing documents. Again, not hiding anything from you. You can look on the MBCA website. These documents are annotated. I sort of spend my life going through them and back through them, this deal and that deal. But, you take what's in the term sheet and kind of split out all of those terms across the documents, so that in the SPA, in stock purchase agreement, you're identifying what's being sold and at what price. Additionally, certain representations are being made by the company, and we'll talk about that a little bit more, especially as that relates to diligence in a moment. Representations by the investor, and that's important too. Conditions to close, so before the deal gets done, X, Y, and Z needs to happen, and that's where the attorney's fees clause goes. In the amended and restated certificate, it lays out the authorized capital structure, so common stock, different kinds of preferred stock, governs the dividends, liquidation rights and preferences, voting rights, protected provisions, indemnification, certain indemnification rights. In the investor's rights agreement, that's where you'll get those registration rights. That's where certain information rights will reside. So investors, especially major investors, so those are, it's a negotiated term, differs on every deal, but typically lead investor and then maybe one or two other investors who put in a large chunk of cash in the company, especially relative to other investors, will require certain information rights. So those might include quarterly financials, yearly financials, a review of the budget, maybe the ability to approve the budget, although that, the ability to review the budget and sort of sign off on that. The ability to inspect the facility upon reasonable notice, those types of things. Pro rata rights, which I mentioned, also go in the IRA, and again, may only go towards the major investors. And this is sort of one of those things where if you've got a major investor category, it's kind of a way maybe sometimes to get people to invest a little bit more so they can get those extra rights, right? It's kind of like upselling them a little bit. But you don't want everybody to have everything, because one of the issues is, as you saw, Series A is followed by, in this model, Series A is followed by Series B is followed by Series C. What you do in the first set of documents for your price round sets the precedent for the next. So absent a huge departure upwards in terms of the company doing way better or the company going way worse, many times you negotiate and push and say, well, we like what we got in place, let's keep it. So, you don't want to give these rights to everybody, otherwise you may need to go out and get everyone's approval to do the next round. And you might have a hangout or two, a holdout or two, who can blow up your deal. Voting agreement contains the board composition and structure, and also has the drag put in there, which we talked about. We talked about the purpose of the drag. And then, ROFR is a standalone agreement, and we already talked about what goes in there. Sweet. Let's keep rolling. Actually, I'm going to take a sip of water real quick. Oh, actually, let me move back a slide. So other documents that are going to need to get put together, and this will come up again as we talk about sort of closing, post-closing matter, but board and stockholder consents. So before you can sell preferred stock, if you need to create preferred stock, then you're going to need a board and a stockholder approval of that. Separate from creating the preferred stock, creating or authorizing the preferred stock, even if you were to sell the stock, you still got to get board approval for it. So looking to see board and stockholder consents. If other folks have pro rata rights or certain other rights, many times we got to get waivers in place. We're going to talk about side letters in a moment. As part of the closing of the deal, everyone's going to come to an agreement on a pro forma cap table, sort of laying out the capitalization of the company immediately after or as of the close. We talked briefly about we'll talk about legal opinion. Not super common in sort of early stage rounds. It generally is focused on the capitalization of the company. It adds a good amount of expense to your deal. So again, that's one reason, especially if it's a smaller round, they're not done. And then, being a realist, or being the realist that I am, I understand that when companies are starting out, their capital is scarce, right? And one of the things the capital gets devoted to first is product and probably marketing as well. And legal is usually kind of behind that, maybe even significantly so. And so many times there's a good amount of cleanup work, especially if there's not been counsel in place, running things. And now I do think it's less expensive to get it correct the first time. It almost always is. And yet also, sometimes, even though it will be more expensive, it's doable once the capital is in place. So frequently there's a lot of cleanup, or there can be a lot of cleanup that has to happen. Side letters are agreements outside of the main financing documents that provide rights to certain investors. Now, one of the pitfalls, and we'll talk about this more if we get there, but is just giving everyone a side letter. One of the issues with this is, again, you start giving some people side letters, then some investors side letters, then other investors want side letters, and all of a sudden you're cutting a whole bunch of side deals. It's a problem because it drives up the legal expense in the near term. And then in the medium and long term, you got to coordinate and make sure that you're adhering to everybody's rights in between financings and in connection with financings. And so it can make the next round more expensive or even undoable if someone effectively gets a blocking right because of some right they had in their side letter. We can spend more time on that if you've got the questions for it, maybe at the back end. But they, will provide for things like information rights if for some reason, an investor wants, some information right that is not contained or in the IRA. Like there's a unique situation there, or an observer seat. Observer seat positions can go in there in lieu of like a board position. Pro rata rights, if for some reason the investor isn't eligible or you don't want to give them pro rata rights in the IRA, the investors' rights agreement. Certain commercial agreements could fall into that bucket, right? So if you're getting an investment from a supplier or a customer, maybe they're cutting some other deal. And then other risk mitigating related covenants and other things, right? So what types of things might be in there? Promise to get key man insurance in place, or bringing down the reps, from the last close if you're doing a subsequent close, or just other things. You'll get, some sort of other evaluation, and for whatever reason it wasn't appropriate or it didn't seem to make sense to go in the main financing documents, or you're doing a subsequent close. So it's a deal where there's an initial close, a bunch of the money comes in, and then you can close additional investors afterwards. Diligence. somebody asked the question, how do VCs know what's going on? Well, on the sort of product tech side, they can send in their experts. They can look at the data. If you're like a health tech company, maybe you're running trials on certain things. On the legal and accounting side of things, there is it's their diligence, right? So on the legal side of things, they're going to take a look at all your corporate records, so all your stockholder meeting minutes and consents, all your board meeting minutes and consents. They want to take a look at your business plan and your financials. Later stage rounds, those financials might need to be compiled or audited even. Securities issuances, again, they're going to want to take a look at making sure, okay, this person's listed on the cap table. Let me see the board consent, let me see the charter authorizing that stock, at the right time. Let me see the board consent of approving that issuance of stock. And let me see the agreement that provides for the sale of that stock. And then let me see, the securities notice filing that need to get done in conjunction with the issuing that security. Securities would include stock, convertible notes, safes, options, warrants, et cetera, et cetera. All your material agreements. So material agreements is important, an agreement that's important to the company. That's sort of a good layman term to put it, I think. And that goes on every side. So like, what are the forms that you're using with your employees? What are the forms you're using with your, you will need to put every employee's employment agreement in there. You'll need to put every certainly if it's I was about to say consultant, you'll need to put every consultant's one in there. I mean, you'll need to do that, especially if they're important. If they're unimportant, you'll still probably do that. But people are really paying attention to the ones that are important. And, if you don't have an agreement in place with somebody and, that's because that person just picked you up at your house, I don't know, you paid your friend $10 to drive you to work or something along those lines. No one's focused or concerned about that. It's dealing with generation of IP of the company, customer contracts, supplier contracts, sales of stock, et cetera, those types of things. If there's any dispute or litigation, investors want to know about that, right? No one wants to buy a lawsuit. That being said, if there is a lawsuit or a threat of one, doesn't mean that a deal won't get done. It just may impact the valuation of the company, and it may make things take a little bit longer. Again, making sure that all the IP is locked down. So, they'll want to take a look at your patent materials and making sure you got all the right IP assignments in place, making sure that, if you got trademarks that, registered trademarks, those filings, et cetera, et cetera, et cetera. How does this happen mechanically? Well, usually there's these days a virtual data room. So whether it's your law firm is hosting it, Box is hosting it, Dropbox, Google Drive, et cetera, in a secure environment, you'll set up these folders and subfolders within them, and all of these documents are getting uploaded. And the investors, their lawyers, their accountants will dig through all of that. And so there's actually some interplay here. There's some interplay between the deal documents and the diligence. So the diligence is about, if I didn't say it before, it's the process during which the investors gather information about the company to identify and assess the investment they're about to make, right? Do we really think this company is that valuable? And, what are the risks to the company? The interplay here happens primarily in the representations in the stock purchase agreement. And those are statements of fact about categories of risk. And when those statements of fact are read in conjunction with the disclosure schedule, which is a schedule, basically a little appendix that's tucked in the back of the stock purchase agreement. When the investor reads the representation, in conjunction with reading the disclosure schedule, which is basically a set of exceptions, all of that is going to be true. And the investor is going to get a a sense for what that risk is with regard to that category. Now, that governs sort of the risk assessment in terms of one of the ways of risk control that there can be covenants, and those are commonly tucked in the investor's rights agreement that the company must undertake or do some action with some period of time. Now, those can be getting key man insurance, right? They're concerned with, like, there's one founder and that person might die, and they'll need to replace that person, and they need to have the money to be able to do that. Or they need to be able to wrap up the company or something along those lines. If you are in a regulated, space, and that's a risk, and the investors are going to be paying attention to see if you're paying attention to that. Maybe you need to, try to accomplish some agreed upon regulatory hurdle in that period of time. And, that can also tie into whether or not all the money gets put in right away or if it's tranched. So that's other ways that they sort of, the interface between diligence and the deal docs. So we are getting close to time. We're also close to the end of our slides. So I'm going to finish our slides, drink some water, and answer more questions. So just to give you a sense for the process, all right, you've decided you want to start a company, you set it up correctly, awesome, good for you. Raise some initial capital, put together that initial team, got some initial customers, again, kind of done all this correctly and buttoned it up, decide you want to raise, it's time to raise venture capital financing, worked with your attorney, thought about what's going to be a good term sheet for you, kind of worked your network, got connected to the right investors, got a term sheet you liked, signed the term sheet, went through diligence, went through negotiating the deal docs, the final form of the deal docs. How do you get this closed? How do you get the money in? Well, closing, that's what we call it. And there can be more than one closing. We mentioned that before. You got to do board consent, stockholder consent, and then that charter, the amended and restated certificate of incorporation, needs to get filed. And then the closing can occur. And we usually kind of do a simultaneous kind of sign and close. So that means frequently all the deal docs get fully negotiated, and then we transmit back and forth signature pages, and we wire back and forth, and the lawyers kind of hold on to those signature pages in escrow until all the money's gotten in on one side, and the investors see that all of the signatures have been received. The company is also seen, and the investors also see that all the signatures are in place, and then boom, magic, it's closed. And then there's stuff to do afterwards. So we mentioned before securities filings. Those are important, and we'll talk about that a little bit more probably in the pitfalls and traps for the unwary section. 228 notices. So these are notices to stockholders letting them know that basically, other things can happen, but commonly it is the amended and restated certificate got approved by the stockholders, and also maybe certain stockholders approved to change the equity incentive plan, also known as an option agreement. Then we issue stock certificates, or if you're using Carta or some sort of other online platform, send them electronically, and then send a closing binder, which is a huge compilation. I mean, it can be, print these things out, 1,500 pages of all the documents fully compiled with all the signatures. That's it. That's how you do a venture capital financing in an hour. Again, I'm Jason Putnam Gordon. I'm gonna take a quick sip of water. We're gonna move on to Q&A. I hope this has been interesting and informative for you. Again, I'm with Pulcinelli. You can connect with me on LinkedIn. I encourage that. Again, don't send me any confidential information, but I do like being part of the ecosystem and providing information to entrepreneurs and other folks in the ecosystem. So always happy to connect. And I do keep office hours. So if you want to set up a time, 20-minute slot to have a general conversation about this kind of stuff we're talking about right now, send me an email, jgordon@pulcinelli.com. All right, Q&A, please use the Q&A function, and I'm going to take a sip of water. And we'll also hit on some of these common pitfalls. All right. So I'm going to start taking some questions. Thanks for hanging in here with me. One question is, how do VCs feel about startups investing under a holding company? So again, VCs are focused on making the return they need to please their investors. So if there's a business case to be made for having a holding company and there are sufficient rights, it can absolutely be done. Sometimes it has to be done. It has to sometimes be done like in a healthcare situation where there need to be subs because either healthcare or even energy, where maybe the holding company has got intellectual property which it licenses to subs that then go out and do some discrete thing like build a solar field or something along those lines. So it can be done. It's the business case that usually drives it. How do VCs deal with co-founders who are market experts but not active? Again, sort of business case. It's a business case scenario for them, but let me give you some information or maybe a framework on how to figure out the right split between founders. And that's like a different conversation as well. But there is no set rule for equity compensation, especially among founders. I think maybe the best framework that I've heard and that I sort of generally convey to clients and other folks in these types of events is, each founder needs to do a deep assessment of what that founder is bringing to the table. Each founder needs to also do that with respect to the other founders on both the short, medium, and long term, right? And I say that because we talked about the venture model. And if these first VCs are putting in money with the expectation that they're getting set return in 7 years, and there's some period of time, some seed financing period of time, which could be a year, 2, very commonly 3, you're talking about a 10-year commitment. So it needs to make sense that each person's level of commitment and what they're bringing to the table over that sustained period of time sort of sets what their equity comp is going to be. It's sort of like a negotiated bargain for situation. Now, vesting helps mitigate some of the risk that if somebody leaves early, they're not going to walk away with their whole chunk of equity, which can really kind of leave everybody else up the creek. But it doesn't really solve everything. So, it's not, lots of people, this sort of quintessential, paragon situation is like, 2 founders, 50% each, not always happen. And it might not be the right thing. Someone's asking whether or not outside rights go into the term sheet. I'm not sure which outside rights or other things they're asking about, so maybe they can re-ask that question. What data room software is typically used? Data site, as I mentioned, typically, most of the time these days, either we will host in our I think we're using Collaborate now in our firm's sort of data site or virtual data room, or Box, Dropbox, or even Google Drive, I see frequently. It's a little bit different than M&A. I feel like M&A, there are a lot of other more proprietary services, VDRs, that are being used. Is thorough branding a consideration? At what point is branding strategy and buttoning up a brand direction good to go? It relates to a customer acquisition. I'm not sure I'm following this, but I will say it depends on the space. If we're talking about branding generally and how interested VCs are in branding, I think it depends on the space. So if you are like in a B2B space, where you're going to have maybe just 5 customers, or I don't know, 10 customers that are large corporates that are not necessarily as focused on brand as if you've got a consumer packaged goods company, or maybe you're going to sell the next best energy drink, or maybe not an energy drink. Maybe it's a drink that is about sort of peace and restoration, or CBD, or something like that. The vertical sort of sets, where the relative importance is on branding. You could, if you were like a med device company or whatever, focused on, some product, some device that only went into folks who are over 65, one of the major, it's all about the investors being able to get their return. So figuring out how you're going to be able to get customers who pay, which in that case is probably going to be mostly Medicare, figuring that out is the nut that you got to crack, and the story that you need to be able to credibly tell. Now, of course, Medicare isn't saying to people, you need to put this device in. It's generally chosen by their physicians or other healthcare providers. But again, different branding play. Please explain how the pricing of preferred stock is reflected in the valuation of common stock. Well, I'm actually not a person who does valuations. There are people who focus on that. Preferred stock is generally greater. The value of preferred stock is generally greater than it is for common stock, 2, 3, sometimes 10x, although sometimes maybe not as much. Depends on the rights and preferences. Now, sometimes entrepreneurs will get very confused because they'll say, well, the pre-money valuation is $40 million, which means that, each price per share is $2.50. I'm just pulling these numbers out. That's what the preferred pay. Why isn't my common also worth $2.50? And the answer is, there's like a little bit of hand waving that goes on, but the answer is also, that pre-money valuation is really a pre-money valuation that is taking into account there's about to be a financing. And it also takes into account that the financing is being done by the preferred stock mechanism, and that preferred stock are getting preferences, those bells and whistles, which we talked about, the liquidation preference, the voting rights, those types of preferences. And so that's why preferred stock is generally valued higher than common stock. What is the best way to handle multinational deals? Great question. So I do work a lot of multinational deals. Depends on the situation. I will say that at the end of the day, this is business, and business is sort of culturally influenced. So when I work international deals versus working Bay Area deals versus working Midwest deals versus working East Coast deals, each one has sort of has a little bit different flavor. It's the concepts and sort of underlying economics are usually the same, but people's expectations as to what's the right kind of liquidation preference, or whether or not this kind of rep should be made or not made, is different. So you got to work with counsel who knows and understands that. That's one aspect. That's the sort of like negotiate the term sheet, document the deal type of aspect. On the sort of diligence side, you generally need to make sure that you're working with counsel and others who are able to help you in that diligence process / the cleanup process, right? Because the way that the US sees intellectual property rights, and they are documented in the US, is different than they are in Australia, let's say, right? And so you got to work with counsel and other folks that can synthesize all of that so that, again, at the end of the day, the investors will get comfortable that the investment they're making is going to get them the return they need so that they can make their investors happy. I hope that answered your question. I got a question about reducing equity from 100% to 22%. So I apologize. I should have mentioned this. I usually do. The numbers and charts and everything, again, sort of made up for illustrative purposes here. The dilution that founders take is different in every situation. There are some founders who still have at or more than a majority control of their company before they go public. There are many, 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 many who have less than 10%. And it's kind of shocking, but it's true. So, it's about, building a good roadmap and plan, and then running those pro forma cap table models so you see what's going to happen coming down the pike. What are my feelings on accelerators? The right ones are great. The wrong ones are not good. Yes. Okay, good. Some people are asking about my common pitfalls. So let's talk about that. Okay, so we've talked a bit about running pro formas, securities laws issues, which dovetails with finders. So securities laws are basically, they're in place at the federal level, which is overseen by the Securities and Exchange Commission, and then at each individual state level here in the United States. Countries outside the United States also have securities laws, so you got to make sure you're complying with them if you're raising outside the US. But at the heart of them, it's about consumer protection. It's about making sure that founders and entrepreneurs and other folks aren't creating sham companies and, sort of worst case scenario, running out and selling bogus stock to, widows and orphans, right? So under that framework, every company that sells a security, stock, convertible notes, et cetera, needs to make sure that they are complying with the securities exemptions. The securities laws. Now, most of the time, there are kind of two ways to do it, right? You don't comply with them. That's not the way to do it, because then you can end up not being able to be financed. You can file an IP, file and go public, but that's not the way to do it right off the bat because it's way too expensive. It's not going to happen. The other is you can look for exemptions. So you work with counsel to make sure that you find exemptions, usually involving accredited investors. That's who you should be raising from, accredited investors in your network. And that's so you can get those securities exemptions. There are some exceptions to that, which we don't have time to go into today, but the peril of not doing that is, one, if you're a fraudster, you can end up in jail, right? But the more common peril is if you don't comply with the securities laws, then the investors may have a right of rescission. In plain English, that means they may have a right to get their money back. And if you're a company that's raised money and you got to give the money back and you've already spent it, where's it going to come from? The answer is it drives your company under it. So one of the sub buckets, I guess, if you will, in securities laws are finders. So these are unregistered broker dealers. These are, here in the US, if a person is going to connect a company to capital, I'm just trying to put this in English, a company to capital and get paid for it, then that person needs to comply with the securities laws, himself, herself, et cetera. At the federal level, that's being a registered broker-dealer. There's some exceptions on the state level that you can kind of fall into that bucket. But the problem is and there are a lot of people out there here, elsewhere in the US, elsewhere in the world, who will say, I will connect you to capital, just give me a percentage. And the problem is that will many times violate the securities laws. And so one, the investors who are putting money in actually ask about that. And it's also a rep that's given. And so you'll have to disclose it, and then they may not want to put their money in. Or if you don't disclose it and they find out about it, or if you don't figure out some other way to remediate this issue and comply, then those investors or other investors may have the right to get their money back, and your company could be sunk. That's the issue with finders. It is a pitfall and a trap. Poor record keeping. So poor record keeping can hurt you in the diligence process, right? If the investors are interested in getting all of your customer contracts and you've never gotten any of them together, then it's a potential risk for them, right? So they're expecting to see in that data room a whole bunch of agreements, right? We're not talking about the seed stage or pre-seed stage when the company is kind of getting together its initial product and getting its initial customers. I mean, we're talking about where you've actually got customers and a product and traction. And so poor record keeping can, one, require a lot of cleanup work, but even more importantly, it can prevent a deal from happening or result in a valuation haircut. And related to that are napkin promises. So these are sort of promises of equity to other people, either proverbially on a napkin, more commonly these days sort of an email, or sometimes just kind of on the phone. That's a problem. So the other question I got is just talk briefly about attorney fees. So I always feel uncomfortable, or that's not appropriate to kind of give people, quotes or fees on this, but I will tell you this. And I'm happy to have a conversation offline, maybe office hours would be a better situation for it. But I will tell you that, at least with respect to doing a venture capital financing, as I said before, the investors are going to ask to have the lead investor is likely going to ask to have some or all of their fees covered. And they will set a sort of a not to exceed amount, right? Could be $25,000, could be $35,000, could be $50,000, could be $75,000. I'm working one deal where it's 150 right now. By and large, at least out here in the Bay Area, where the company usually ends up doing the initial drafting, and there's usually a bunch of cleanup, that just has to get done because that's what happens in these deals, because there's some deferred legal maintenance. Certainly would not expect counsel fees to be less than what the investors' counsel's fees are going to be. Many times it's 1.5x or 2x. It can even be up from there. So with that in mind, I guess maybe I'm going to take a drink of water and then take a spin through the chat session, unless anyone else has got any other questions. Great. Well, I'll give it maybe 10 more seconds. If there are no other questions, I'm going to sign off. All right. Well, again, thank you very much for attending, attendees. My name is Jason Putnam Gordon. I'm a venture capital emerging growth company attorney with Pulcinelli. Connect with me on LinkedIn. Send me an email if you'd like to. Do an office meeting. Happy to do that virtually, obviously. I appreciate this question for what's the meaning of life. I'm working on that myself. I want to thank Idea to IPO for having me here today. And you've been learning and listening about how to do venture capital financing. Hope you found it helpful. With that in mind, it's been a pleasure to be here. I'm going to let you get back to building your great company. Take care. Bye-bye.